I'm Nadia Gurwell.
I'm John Gugliatino.
I'm Michelle Blanchard. Welcome to 30 Minutes.
Hi, my name is Bob O'Potsner, and welcome to 30 Minutes. I'm an attorney in Danbury, Connecticut with the law firm of Collins and Hannafin, and I'm starting a series on 30 Minutes of introducing the public to certain issues in the law. Today the topic is probate and elder law, and with me today are two very renowned people who know this area very, very well. To my right is Judge Diane Yeaman, probate judge of Danbury area. And to her right is Paula Boa Souza, who's a law partner of mine at Collins and Hannafin PC. Hello, ladies. How are you?
Good to see you. Hello.
Diane, Judge Amy, would you please give me a little background of yourself, and then I'll have Paula do the same thing, just to let the people know what you do and who you are.
Sure. So I've been the probate judge in Danbury for the past 28 years. I'm in my 7th 4-year term, and I will actually be running for election again in November. I'm also an attorney with the law firm of Yeaman & Yeaman, which is a family law firm, and I specialize there in mostly estate planning, and I help my husband and his brother with real estate. I'm also involved with the National College of Probate Judges, which is related to the judges in that I am part of the organization, which is over the whole country. We have conferences twice a year, and I'm on the executive committee of that. I'm also the Connecticut State Representative, and I'm also in charge of membership of that organization.
Thank you. Paula?
Thank you, Bob. Yes, I'm an attorney admitted in the state of Connecticut. I've been admitted for a little over 10 years, and I focus my practice on estate planning, which includes preparation of wills, healthcare instructions, and powers of attorney, as well as estate administration and dealing with various matters in the probate courts, including conservatorships, as well as elder law matters. So that includes questions regarding long-term care and how one goes about paying for that long-term care, including Medicaid applications.
Thank you. Judge Yeaman, what is the probate court?
So the probate court system in Connecticut is a state court system, similar to that of Superior Court. Probate courts in Connecticut have elected judges. There's 54 probate courts in all, so we're regional. When I was first elected many years ago, there were 133 courts, so over the years they've been consolidated. And so the probate courts in this area include mine, which is the Danbury Probate Court, which jurisdiction is just the city of Danbury. And the other area courts include New Milford, which is the Housatonic Probate Court, and that was consolidated years ago and now includes the towns of New Fairfield, Brookfield, Bridgewater, New Milford, and it's that whole region. The other probate court in the area is the Northern Fairfield County Probate Court, and that includes the towns of Ridgefield, Reading, Newtown, and Bethel. So the consolidation has made the courts more uniform. And also, would you like to hear about the jurisdiction, or we'll get to that?
We'll get that in a few moments.
Sure.
Now, Paul, please tell us, how does one decide which probate court they have to go to for the particular issue? Do they get to choose whichever one they want to go to, or are there particular rules?
Most often it's based on where the person is located. So with an estate, if the person died a resident of a certain probate court's jurisdiction, that's where they would submit the documents for the estate administration. If there's a conservatorship matter or any other matter, it's based on the location of the principal of the matter.
I see. In the process of probate matters and jurisdiction that you have, there are many things that are being done or are done by law in the probate court that people may not realize. And one particular issue might be involving the conservatorship of a person. And I think that might be a topic that might be a good starting point for today. So Paul, would you please tell me, under what circumstances might a person need to have a conservator or conservatrix, if it's a female? What's the purpose of a conservatorship?
So I think the first thing that's important to realize is there are two different versions of a conservatorship. There's a voluntary and there's an involuntary. And they can be very different in that with a voluntary conservatorship, there's no declaration of incapacity. A voluntary conservatorship is done when someone says that they need help with handling their finances and their personal affairs, and they'd like to have someone appointed by the court to handle those matters. But they don't want to go so far as to say they're completely incapacitated because they believe they can still do a lot of things on their own. And the important reason for doing that as opposed to signing a power of attorney is that with the conservatorship, it's under the purview of the probate court. So the probate court can keep an eye on making sure the conservator is acting appropriately.
When you use the word incapacity, Judge Amy, what does incapacity mean?
So incapacity, when it comes to conservatorships, is really a standard that we're looking at whether a person's incapable of managing their affairs, the financial affairs, even with assistance, and also whether they're incapable of caring for themselves. So the court has to make those findings in order to grant an involuntary conservatorship.
As I understand it, and I have as a litigator been in probate courts for litigation of will contests and that kind of in conservatorships, am I correct there's a concept called conservator of the person and conservator of the estate? Paul, is that something that is part of the parlance in the field?
Yes, absolutely. The conservator of the person handles matters such as making sure the person is going to their doctor's appointments, if there are nurses' aides or other medical professionals that need to be circling in and out of the house to care for the person, ensuring that they're scheduled and the person is being cared for appropriately, all of those personal affairs. Whereas a conservator of the estate's job is focused on making sure if there are deposits or other monies due to the conserved person, those are being received and deposited. And if there are bills to be paid for the person, making sure all those bills are being paid. In addition to that, if the person qualifies for any state assistance, it's the conservator of the estate's responsibility to ensure that the benefits that are available to the person are being sought after and received. Many times, the conservator of the person and the conservator of the estate are one and the same because it's most efficient in that way. But there are certain circumstances where it makes sense for one person to act as conservator of the person and another to act as conservator of the estate.
Now, there are occasions in which families, unfortunately, when the elder one, typically it's an elder person, although it could be a conservatorship for a young person under certain conditions, but sometimes families don't always agree. Not because someone's being bad, but because there's a different philosophy. So when you have a conservator that's being appointed either of the person or the estate, and it's agreed upon situation, the court still has to make sure certain criteria is met. But when you have a disagreement, then that's when the judge has to make the decision as to A, if there's going to be a conservator appointed, and B, who is going to be that person. Am I correct in that regard, Judge?
Yes, for the most part, it's very important that the court have a full hearing in order to determine everyone's opinion. And sometimes even if there's an agreement, the court still has to make sure that the conservator that's being appointed is the appropriate party, and we do background checks, and the statute provides for certain provisions we have to consider when we decide who's going to be the conservator.
And if there is a dispute, and you're going to have a hearing at the probate court, how does a judge go about deciding whether or not the person is incompetent? Is that the right word, incompetent, or is that the right word?
We usually call it incapable under the statute.
Okay.
But
How do you determine whether or not the person is incapable?
one of the requirements of an involuntary conservatorship is that the court requires a medical evaluation that's submitted at the time of the hearing or before the hearing, and that medical evaluation is extremely important. We have to review the medical evaluation and determine the medical condition of the patient or of the client. So the court will have a hearing on that. And with the voluntaries, though, because they're voluntary and people want a conservator, there's no medical report required on those.
Well, so we have a situation where the judge would hear the decision and make a decision as to whether or not, based on the evidence, there should be an appointment of a conservator. You, Paul, would be the person who would go to probate court and have to show if your client is incompetent or incapable and needs to have one appointed. When someone walks into your office, Paul, and says that my mother, my father, my relative, for example, needs to have a conservator appointed, how do you handle that opening interview with the client? What do you tell them in that situation?
Well, I think the very first step is to make clear who the client is. Is it the individual who is requesting, who thinks that conservatorship is needed for someone else, or am I there to represent the person who may at one point be conserved? And so in the situation you just described where there's a family member, then I would be representing the family member and having the parent or whoever it is conserved. What happens is when the application is filed with the court, the judge will then appoint an attorney for the parent in this example. so that, of course, the parents' rights are represented in the matter. But then I will discuss with this family member what the process is like and what the hearing will be like. It's important for them to know that these hearings, especially with the involuntary conservatorship, are under the rules of evidence. So there is question and answer in order for the judge to hear the evidence of whether or not this situation merits appointing a conservator for this person.
Do you usually get involved in talking to the mental health professional or the doctor to find out whether or not the person who is allegedly incapable is in fact incapable?
That's usually done by way of the probate court form known as the physician's evaluation form. And so the doctor will prepare that and sign it, and then that original document is submitted to the court as evidence. That there have been times when doctors have testified at the hearing, but it can be difficult for a number of different reasons to have the doctor present, and so the physician's evaluation form acts on its own.
Judge, now when you see a doctor's report or a form filed, what do you look for in that report to see whether or not you believe the person needs to have someone appointed as his or her conservator?
There's some questions that are on that form, which includes the person's ability to make decisions impaired, yes or no. So we're looking specifically at those answers, but also we're looking for the detail that follows up. There's specific questions on the form and places where they have to list what their condition is. So we look at that as in totality. But we're also going to take evidence at the hearing as well. There'll be some testimony often from family members that bolsters concerns that they have, and then we consider those as well, of course.
What happens if you have, for example, a brother and sister who disagree whether mom is or is not incompetent or incapable? I use the word incompetent, I don't mean to be disrespectful, but that's a phrase that used to be, I think, the rule. What happens if you have a difference of opinion, where a brother, for example, says mom is incapable and sister says no, not? What do you do with that situation, Paul, when you get faced with that?
Well, again, I think the first job is to determine who your client is. So obviously, I would not be representing both brother and sister. So if I were to say be representing sister, then it would be up to brother whether he's self-represented or whether he obtains his own counsel. And then it's a matter of being at the hearing with a full slate of evidence to show if sister is looking to have mom conserved, why mom needs to be conserved. Judge Yemen touched on some of the items she looks for in the physician's evaluation that's submitted. As an attorney representing someone that wants to move forward with the conservatorship, it's a matter of getting witnesses in that can testify to the fact that they've experienced scenarios in which mom has been a danger to herself and that have caused things that have caused risks to mom's livelihood, such as bills going unpaid or medications not being taken when they should be. That would cause reason to have the conservatorship put in place.
Judge, what happens when the children, for example, say that mom or dad is incapable, and the person who's allegedly incapable says, no way, I know exactly what I want to do, they're just whatever. How do you handle that? Do you have someone appointed to represent the incapable person separate from the parent, the children who want to get involved? How do you handle if there's a dispute from the person who's allegedly incapable? What do you do from the probate court's perspective?
Well, the person the respondent is who they're called. If there's a conservator application filed for someone, they're the respondent, and they have a right to have a court-appointed attorney who will advocate for their interest in what they want at the hearing. So there's often these disputes. The court encourages people to work things out. We often take recesses to allow them to go into separate rooms and try to talk things out. But it's often the case that the person does not want a conservator and feels they can handle everything very well. And the court will hear their testimony and hear testimony of other witnesses that they bring, and we'll look at the physician's evaluation, and we'll take kind of the totality of the whole hearing when making those decisions. And often there's different opinions of family members and neighbors, and we hear from everyone.
Now, it's not inexpensive. You've got lawyers potentially involved, you've got doctors, mental health professionals potentially involved. What happens, Judge, when people don't have the money to go to court, go to probate court, and have an important issue, and let's suppose it's not about over the estate, the size of the money they're dealing with, but rather over mental health issues or other medical, do we need an operation or whatever. What happens if people can't afford to hire a doctor or a lawyer? What do you do in the probate court? Is there any resource available?
Well, there are fee waivers available. The filing fee for all applications are generally $225, and the fee for estates is based on the size of an estate. So as far as people that cannot afford to file applications, they can file a fee waiver if they meet the criteria for that. It's similar to the standard of getting a public defender, for instance. If they qualify for a fee waiver, they can have the filing fee waived. They can also have the state marshal fees waived, and they can have the probate fees waived, depending on whether they meet the criteria.
But what about the legal fees and the medical fees, Paul? What happens there? If people can't afford the process, is there a state assistance program of some type?
So there are times when people will try to go about it themselves, and so they'll obtain a copy of the application that's required, they'll obtain a copy of the physician's evaluation that's required. Maybe at their next doctor's appointment that's scheduled, they'll have the physician fill out the form in connection with that, and they'll try to go about it themselves, but it can be challenging because the general public is not familiar with the rules of evidence, and that's what needs to be followed in these matters. And it can make going through the process a bit more challenging, but there are times when people can't afford otherwise. That's the way they go about doing it.
Paul, I recently had my will done, and you were the attorney who drafted my will, and there were a bunch of forms I filed and signed with you that involved health care and other issues. Are there forms that can be filed and prepared to avoid maybe having controversy on the issue of conservatorship?
Yes, I would strongly suggest to anyone to have healthcare instructions and powers of attorney in place before they lose capacity. They are invaluable, really, in the sense that the cost to prepare those documents is minimal compared to a lot of the costs and the fees we just went through with the conservatorship process. Above all, it's your opportunity while you're of sound mind to say who you would want to take care of your affairs if you ever lost capacity. So I don't know if you want me to go through the different items in those forms and what they cover, but
Maybe
they're very important.
Not yet, but Judge, how would those kinds of forms make it easier in the process X years later when after the forms are filled out, assuming that the client followed his lawyer's advice, which some of us don't always do. How do those forms help you in the process to make the conservatorship dispute, if one ever occurred, more amiable, more amicable?
Sure. And we, of course, also recommend those forms. It's always good to have that estate planning in place, and you can actually avoid a conservator if you have a power of attorney and that works and they're doing a good job and there's no dispute. But like you said, when there is a dispute and then we are into court, the probate court has jurisdiction in these situations under the new law last year to modify or to either suspend, revoke, or keep that power of attorney in place when we appoint a conservator. So we might end up appointing a conservator over estate, but keeping the power, the healthcare decision-making in place, and we may end up suspending the power of attorney and bringing it back into place later on once things are resolved. There's a lot of different ways of handling the situation. I
recently heard of a situation where someone went for surgery, and the doctor's assistant said, by the way, do you have your health form in case something goes wrong? And it was an interesting question when someone called me and asked me about that, and that is sometimes asked for. So sometimes when you have surgery, it may not be a bad idea to bring your forms with you. Paul, you mentioned power of attorney, and people don't always know what that means, or may have a different viewpoint, and plus since the law has changed recently, they may be outdated. Do you want to talk a little bit about what is a power of attorney and how does that work?
Sure. So a power of attorney is strictly a financial document. It used to be, prior to 2006, that the power of attorney included the ability to make health care decisions, but that's no longer the case. It strictly has to do with financial matters. And it's a document whereby you appoint someone else to handle these financial matters for you. Now, the standard power of attorney is effective as soon as you sign it, so it's very important for people to understand exactly what they're signing when they sign it. They might be under the impression that this is only effective when they lose capacity, and that's not the case with the standard form. There's a springing form that allows you...
Springing? What does springing mean?
The springing power of attorney is a statutory document which gives you an additional option with the power of attorney. It's called the springing power of attorney because it only springs into action upon a stated occurrence, and that occurrence is usually the principal, the person signing the document, losing capacity or being unable to act on their own behalf. And the way it works is it comes with an attached affidavit that would have to be signed by a physician in front of a notary and 2 witnesses declaring that this person is now incapacitated. And it's only once that affidavit is signed that that power of attorney could be used.
Judge, can a power of attorney be useful in having real estate transferred?
Absolutely, and when the power of attorney is used to transfer real estate, it needs to be recorded in the land records along with the deed that's used to do so.
The person who is they call it attorney in fact, is that phrase still used, the attorney in fact, who is the obligation?
I believe it's now the agent under the new rules.
Agent, okay.
It
So
is.
I'm a little older than the other 2 of you, but when the agent acts, does the agent have any kind of fiduciary obligations? And with that, I mean, can he or she spend the money however they want for the person whose money they're holding, for example, or do they have certain limitations on how the monies are used?
They have a fiduciary responsibility to handle the money, only for the person that they're handling it for. And also, the new Power of Attorney Act, as of last year, has a whole host of new requirements, such as requiring them to have record keeping. And it also allows, a number of parties to now go forward and ask for a power of attorney accounting in the probate court. Before, it was very limited who was able to ask for those accountings.
So, Paul, if I understand it correctly, if you are an agent of a power of attorney, then you have some fiduciary obligation. What does that mean, by way of example? How is it different to act as a fiduciary with funds in that situation versus how you'd spend your own money?
Well, of course, when it's our own money, we can spend it as frivolously or as wisely as we want. But of course, when you're taking care of someone else's money, there's a heightened level of responsibility. So you have to ensure that you're really using the money to meet their needs and not spending it on extraordinary things. You have to be very careful about gifting amounts and really just taking care of the expenses that they need to maintain their standard of living.
Let's suppose that I do a power of attorney and I name one of my kids as the agent and decide, maybe that person's not the one to do it. I want to change my mind. Can I change my mind?
You can always revoke a power of attorney.
How do you revoke it?
Tear it, and you have to give notice to the person you gave that power of attorney to. But it's also important to not have 10 copies or 15 copies floating around, because you want to be able to go back and retrieve those power of attorneys that are out there so they're not in the community and being used against your wishes.
Paul, when you have a client who signs a conservatorship, a power of attorney, do you keep a copy of that in your office as well?
I do.
You do. We have only a few minutes left in the show, and I'd like to get into perhaps some changes in the laws. We've all heard about the tax changes that have some impact on the federal estate issues, et cetera. But, Judge, are there any laws in Connecticut that are relevant to this process of probate court that we should be aware of? If you have any statutes you want to talk about that we can discuss?
Yeah, there's a couple I'll just mention briefly. There's a new procedure on landlord-tenants, so that if a tenant passes away, then the landlord has a procedure to go through and be able to do the probate so they can get the property out of their apartments. So it's kind of an easier procedure. Also, a new law on age to marry.
Before you leave that, I'm sorry. So what was the problem before that was needed to have a new statute, Paul? What was the issue?
I think Judge Yeaman is more well-versed on that particular statute.
Yeah, well, basically, before it wasn't really clear. There was a cumbersome procedure where they would file a notice to the next of kin. They'd have so many days to get the items out of their apartments, but it was kind of a long, cumbersome procedure. This is kind of a more streamlined, more detailed procedure on how it's handled. Different forms that need to be filed, and that way, after a certain period of time, it's more clear that they'll be able to then go into the apartment and not have to do an eviction proceeding.
Sure, I see. This is for the landlord, essentially.
It's for the landlords, essentially.
I understand there's a new law that relates to the age of getting married. What's that new statute?
Interestingly, yeah, in Connecticut, historically, the age to marry has changed, and the old law was basically that if you're under 18, you need your parents' permission to marry. Under 16, you need the probate judge's permission to marry. The new law is that now if you're under 16, you can't be married.
You cannot be married under law.
So you have to be at least 16-year-olds to get married. And now the law has changed. Instead of needing the parents' permission, you now need the probate judge's permission to get married if you're under the age of 18.
But if you're 16, you cannot get married.
Correct. Under 16, you cannot. As soon as you hit your 16th birthday, you can get married. But you do need the probate judge's permission if you're under 18.
Not for today's discussion, but there might be some interesting constitutional issues under the law as to whether or not that prohibition is going to be upheld, but we'll say that for another day. Paula, if someone wanted to contact you to talk about any of these particular issues, how does one reach you? How would you, if someone wanted to call you and ask you about some of these issues or other issues, do you have a website or an email address or something people could reach you and et cetera?
Yeah, so phone is a great way to contact me. It's 203-744-2150. Or via our website, that's also a great way to communicate with me through the firm, www.chlaw-ct.com.
Okay, I'm sorry, could you get me again how to reach you a little slower? I didn't have all the information.
Okay, so the phone number is 203-744-2150, and the website is www.chlaw-ct.com.
That's also mine. Judge, how does one reach your office if they need to come and ask some questions? And I know you have a wonderful staff of people who help people out all the time. I've been there in the probate court, even though I don't do this kind of work typically. I do more of the will contest and those kinds of things. Whenever I go there are many people who help out. So how does one reach your office and get the information they may need to decide what's going on and how to get help?
The probate court in Danbury's number is 203-797-4521. I'm not allowed to talk to people outside of hearings, so if there's a case pending in my court, I'm not allowed to speak directly to individuals, but like you said, I have an amazing staff.
Amazing.
And there's also a very helpful website that has all the probate forms online, as well as user guides in different areas, such conservatorships. And that probate website is www.ctprobate.gov, so it's pretty easy.
And if someone comes to your office and asks a question, do you have people who actually will help them identify what the issues are and talk a little bit to them about how things proceed?
Yeah, the clerks will, when they come in with their situation, will give them the proper forms and procedures. They're not allowed to give legal advice, but they certainly will guide them and tell them what they need to do in order to have their cases heard.
I see. And Paula, do you have any last-minute tips for people who are watching the show as to things they should think about in terms of any of these issues we've talked about today, conservatorships or power of attorney? Do you have any last-minute tips that you want to tell the people?
We touched on it earlier, but I would definitely advise that people do estate planning. It's always good to have your wishes set down on paper, both in terms of how you want to distribute your assets, who you want to put in charge of your affairs, and also talk to your family members. You can name someone to be your healthcare representative, but it's important that they also know what your wishes are.
You two have been wonderful guests. This is my first hosting. I've been a guest 3 times, but being a host is a little different because I have ideas that I'm not expressing. I want to thank you both, Judge Yeaman and Paula, for coming, and maybe we'll have another show later in the year on some other issues that become important. This is Bob Potzner saying thank you very much and welcome again to 30 Minutes.